And now it's time for another case law update. Today's update covers Clifton versus Johnson, a royalty dispute decided by the Texas Supreme Court, and yet another double fractions case. In 1951, 3 people, including H.D. Cornell, executed a deed with Y.H. Holcomb. Someone handwrote royalty deed at the top, and the deed conveyed an undivided 1/128th interest in and to all oil, gas, and other minerals in and under certain tracts of land in Reeves County. The deed further stated that the grantees should, in future leases, receive only a 1/128th part. Immediately following that statement was a parenthetical stating 1/16th of the usual 1/8 royalty. For 70 years, the grantees and their successors received a 1/128th royalty until Johnson, a successor of Holcomb, claimed the deed provided for a floating 1/16th non-participating royalty interest rather than a fixed 1/128th. He argued that, in old leases, 1/8 sometimes meant the entire mineral estate, so the parenthetical of 1/16th of the usual 1/8 conveyed 1/16th of the entire mineral interest, rather than a double fraction multiplied together to reach 1/128th. Johnson sued the Cliftons, the successors of Cornell, in district court. The district court held that the royalty deed conveyed a fixed 1/128th interest for the amount paid for 70 years. Johnson appealed, and the appellate court awarded judgment to Johnson based on the holding in Van Dyke versus Navigator Group, another case involving double fractions, which you can hear a summary of on my friend Tim Powell's podcast from about 1.5 years ago. The Cliftons challenged the appellate court's holding, and the Texas Supreme Court accepted the case for review. On appeal, the question was whether the 1951 deed's use of 1/16th of the usual 1/8 royalty, parenthetical, referred to a fixed 1/128th interest, which the Cliftons asserted, or whether the deed meant to convey a floating 1/16th interest of the entire mineral estate, which Johnson asserted. The court first analyzed the double fraction issue. To determine if a grantor intended to reserve a royalty interest, courts look at the deed's language. In Van Dyke, the court recognized that the antiquated mineral and royalty deeds used a 1/8 as an official legal term to mean the mineral estate, and that if a drafter wrote 1/2 of 1/8, they meant to convey half the mineral estate, rather than the product of the double fractions, or 1/16th. Van Dyke directs courts to presume the use of 1/8 in a double fraction is purposeful and used as a legal term for the mineral estate. However, Van Dyke also cautions courts to be careful and explains that if a deed expressly uses provisions showing 1/8 to be a fraction rather than a legal term, then courts should multiply the 1/8 by the other fraction. The court held in favor of the Cliftons. It reasoned that the parenthetical explained the sum of 1/128th as multiplying 1/16th by 1/8, rather than intending 1/8 to be used as the term for the mineral estate. Thus, the Van Dyke presumption did not apply. Further, the court pointed out that without the parenthetical, the deed would simply state 1/128th, removing the double fraction confusion. The Texas Supreme Court reversed the Court of Appeals judgment and reinstated the district court's judgment, holding the 1951 deed conveyed a fixed 1/128th non-participating royalty interest in future leases. So why does this matter? These double fraction cases are becoming more and more common since the Van Dyke ruling, as litigants test the boundaries of what that ruling means for Texas law. We will continue to follow these double fraction cases and keep you updated on what they mean for your interests. That's all for today. I'd like to thank Frances Warden, a law clerk in our Denver office, for her help with this update.